Fine. Well, just to assist your lordship, a small list of dates has been made. Hey, তোকে দিচ্ছি কপি আর কপি আছে। Well, your lordship will kindly see in 1989, the case Engineering Services Private Limited was incorporated. Initially the wife of the opposite party number 2 and others were the shareholders, and the opposite party number 2 was involved as the director of that company.
OP2.
OP2. Presently, as we have said in that list of dates, presently the petitioners number 1 and 2 are the directors of case, and the petitioner number 3 is a manager. Now, in 2019, 13th of September 2019, a company named Millennium Real Infra Private Limited acquired the entire shareholding of CAIS. Petitioners number 1 and 2 are the directors and only equity shareholders of MRIPL. So in 2019, MRIPL takes over CAIS, the entire shareholding. On January 8, 2021, a company named E&C Infrastructure Private Limited, having its registered office at it's in UP, Noida, acquired the entire shareholding of CAIS from Millennium Real Infra Private Limited. Hence, CAIS is a wholly owned subsidiary of E&C. 85% of E&C's equity shares are held by the petitioner number 1.
What is EMC?
Well, E&C is what has happened, there are two companies, MRIPL and E&C.
MRIPL and
E&C. The third company is CAIS.
Yes.
Now, the entire shareholding of CAIS was taken over by MRIPL in 2019. In 2021, MRIPL sold the entire shareholding of CAIS to E&C.
ENC Infrastructure Private Limited.
So E&C became the owner of CAIS. Now, both these companies, MRIPL and E&C, are owned by the petitioner numbers 1 and 2. Owned by means by shareholding, 100% shareholding.
Both the company?
Both the petitioners, 1 and 2.
Both the petitioners are owner of the ENC and as well as
MRIPL.
MRIPL.
And by the fact that CAIS is, the entire shareholding of CAIS is owned by E&C, so they also become the effective shareholders, and the entire shareholding of CAIS is owned by them.
Petition number 1 and 2.
Yes. Now, kindly sees 13/9/2019. At the time of acquisition of the shares of CAIS by MRIPL, the directors of CAIS were the opposite party number 2, Mr. Shankar Pine. Opposite party number 2 is Taposh Kumar Choudhury. Mr. Shankar Pine, Mr. Rupasri Bose, and Mrs. Anjana Choudhury, wife of OP number 2. The opposite party number 2 held 9.70%, and Mrs. Anjana Choudhury held 5.59% shares of CAIS. So together they held about 15 point something percent in CAIS, which they sold to MRIPL. MRIPL sold to CAIS. CAIS was facing bankruptcy, and recovery proceedings were initiated by Bank of Baroda Kolkata branch against CAIS and the opposite party number 2. In the said recovery proceedings, even the personal property of the opposite party number 2 had been put up for auction. They had mortgaged. Well, your lordship knows, when the company takes loan, personal guarantees are to be given by the directors or the shareholders. Their entire house, which was there in the southern part of this city, was also given as mortgage, collateral against that loan. Because of the situation where Kais was unable to pay, their entire building also was taken over and was put up for auction. Then the next page, September to November 2019. At this stage, MRIPL came to the rescue of Kais as well as the opposite party number 2 by acquiring the entire shareholding of Kais through infusion of funds and settling all outstanding loans of Kais due to Bank of Baroda. As a result of this, not only Kais but even the opposite party number 2 was saved from bankruptcy in as much as another personal property belonging to the OP number 2 and his family was saved from being sold by the Bank of Baroda. Malad, accordingly, we have given the documents also. We have annexed those documents. Your Lordship can get the page numbers from there also on the right.
Page 38.
Yes. So I'll take your Lordship slowly to that, but I'm placing the list of dates as of now.
Yes.
Then September to December 2019, in lieu of such funds paid by MRIPL, the opposite party number 2 and the other shareholders agreed to transfer their entire shareholding in cash in favor of MRIPL, and share transfer took place accordingly upon adjustment on per share of the value of money which had already been paid by MRIPL to pay off the loan to the opposite party number 2 and cash to Bank of Baroda. The opposite party number 2 was retained as a director of cash.
In spite of taking over the case, BW2 remained director.
Yes.
Director, yes.
He only remained the director, he did not remain the shareholder.
BW2.
Then 13.9 again, in accordance with the terms and conditions of acquisition of CAS by MRIPL, the directors of CAS at that time, namely Mrs. Anjana Choudhury, wife of OP number 2, Mrs. Ruposri Bose and Mr. Shankar Pine, resigned as directors of CAS. In place of the resigning directors, the petitioner number 1 and one Mr. Jayabardhan were appointed as directors on the board of CAS. Then 17/8/2020, the petitioner number 2 was appointed as a director of CAS. Petitioner number 2 is the wife of petitioner number 1. And Mr. Jayabardhan resigned from his post effective from 18th of August 2020. Thereafter, as mentioned above, on 8th of January 2021, E&C acquired the entire shareholding of CAS from MRIPL. Then May 15, 2021, shareholders of CAS submitted a special notice to the board of CAS for removal of the opposite party number 2 as director of CAS for his professional misconduct. An intimation letter was sent to opposite party number 2 by CAS along with a copy of the special notice giving him the opportunity to make a representation to CAS. The intimation letter further stated that if CAS did not receive a representation from him, then he will be provided an opportunity of being heard at the extraordinary general meeting of CAS scheduled for May 29 to 2021. A video link was also sent to opposite party number 2 asking him to make an online representation at the EGM. Then May 29, 2021, that's the date for the EGM. The opposite party number 2 neither presented himself at the EGM, nor did he make a representation against his removal through video conferencing. As a result, the EGM was duly convened on May 29, 2021. In the said EGM, the shareholders held that opposite party number number two's continuation as director of CAIS was inimical to the interests of CAIS and accordingly adopted a resolution removing him as a director on the board of CAIS.
Hmm.
Then first week of June 2021,
Hmm.
while attempting to file Form DIR 12 with the Register of Companies Kolkata for reporting opposite party number two's removal from CAIS, it was found that the website of ROC did not allow uploading the relevant documents in this regard on behalf of CAIS. It was found that in order to preempt his removal as a director, the opposite party number two had filed a fraudulent form DIR 12 with the ROC on 28/5/2021, that is 14 days after he received a copy of the special notice regarding the EGM. Through this fraudulent form DIR 12, the opposite party number two tried to illegally show that the petitioners numbers 1 and 2 have been removed as director of CAIS. So what he did, immediately after he received this notice on the May 15, 2021, on 28th, he filed a false and fake DIR 12. DIR 12 is the document by which the removal of directors are notified to the ROC. So he filed a DIR 12 saying that petitioner number 1 and 2, who are the only shareholders,
They were removed.
they have been removed.
Hmm.
Then 11th of July 2021, 12th of July 2021, and 17th of August 2021. On 11th of July 2021, the fraudulent form DIR 12 filed by opposite party number 2 was rejected by the ROC as opposite party number 2 failed to provide requisite documents to the ROC proving that opposite party number 2 is the owner of CAIS and is entitled to remove petitioner number 1 and 2. Upon non-acceptance of fraudulent form DIR 12 filed by the opposite party number 2, petitioner number 1 signed and filed the form DIR 12 in respect of removal of opposite party number 2 as a director of CAIS on 12th of July 2021, which was accepted and taken on record by the ROC on 17th of August 2021. As on date, the official website of the Ministry of Corporate Affairs, Government of India, clearly reflects the removal of opposite party number 2. It is required to be noted that the removal of opposite party number 2 was effective from 29th of May 2021, that is date of EGM approving removal of opposite party number 2. Then 13/8/2021 and 20th of August 2021. Police complaints had to be lodged as the opposite party number 2 took advantage of his physical presence in Kolkata and forcibly took over the control of CAIS's then registered office situated at 5 Fancy Lane, Calcutta, and did not allow the authorized officers of CAIS to enter the premises to access the statutory documents and other records of CAIS. The opposite party number 2, in order to hide his misdeeds, had misappropriated the statutory records and other documents of CAIS. The complaint is at page 98. Then September 2021, after removal of the opposite party number 2 from CAIS, which was approved by ROC on 17th of August 2021, the process of removing him as authorized signatory from different bank accounts was initiated. And upon his removal as the authorized signatory from CAIS's bank accounts, the bank statements were handed over to the current directors of CAIS, that is the petitioner number 1 and 2. From the said bank statements, it was revealed that taking advantage of the fact that prior to his removal, the opposite party number 2 was the signatory in respect of the said accounts, he, in conspiracy with his wife and one Rajinder Prasad Gupta, proprietor of Golden Enterprise, misappropriated and siphoned off the funds of CAIS totaling to rupees 95,49,005 rupees. Such funds of the company were transferred by the opposite party number 2 to his personal accounts and the personal accounts of his wife and said Rajinder Prasad Gupta. Then 15th of September 2021. It was informed by TRD Southeastern Railway, Kharagpur, that the opposite party number 2 had misappropriated a performance bank guarantee to the tune of rupees 20,84,800,985 in respect of a completed project by impersonating as the authorized representative of CAIS. The opposite party number 2, along with his men and agents, criminally trespassed into the godown of CAIS situated at Jorhat Shakrail, Howrah, and took forcible control of the goods of the godowns and stock lying therein. Then 22nd of September 2021, a complaint was also lodged with the Hare Street Police Station regarding the misappropriation of funds by CAIS by the first party and others, but
by
no
opposite party number 2.
By the opposite party number 2 and others, but no first information was lodged. Then 7th of October 2021, CAIS was constrained to file an application under section 156(3) of the Code of Criminal Procedure through its authorized officer and on a direction passed by the learned Chief Metropolitan Magistrate, Hare Street Police Station, case number.
Mr. Ganguly, what is the what does it mean? Dated 22nd September 2021, a complaint was
lodged by the petitioners.
Petition.
Yes.
But no first information report was lost. What does it mean?
Was registered. It would be
also lost registered.
Was registered.
Registered. Lost on with
lodged. Kindly deletes that on.
The Hare Street Police Station regarding misappropriation of funds of
by CAIS.
Opposite party number 2.
Yes.
Who was filing?
This was filed by the petitioner number 3. 3. He was the manager, so he filed it.
But no first information. That is formal FIR was not. FIR was not registered.
Registered.
Yes.
Well, that's why on the 7th of October, we filed a 156(3) application, which was duly allowed by the magistrate. Then 16th of March 2022, suppressing material facts.
156(3) filed by 3.
By 3.
3.
On behalf of CAIS. Then 16th of March 2022, suppressing material facts, title suit number 637 of 2022, filed by the opposite party number 2, and title suit number 639 of 2022, filed by his wife, ex parte ad interim injunction was passed by the learned judge, bench number 12, City Civil Court at Calcutta. Therein restricting transfer of the shares to any third parties. Then 12th of April 2022, petitioner number 1 and 2 filed application under Order 7, Rule 11 of the Code of Criminal Procedure 1908 in both the titles. Court of Civil Procedure. Yes, in both the title suits before the learned judge, bench 12, City Civil Court, inter alia on the ground that the issues which are not maintainable before the learned civil court, on the ground that the issues are not maintainable before the learned civil court, since it concerns a company subject to the jurisdiction of the Honorable National Company Law Tribunal alone under Section 430 of the Companies Act, read with Section 9 of the Civil Procedure Code. 'Code. 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 ' Then on 7th of April 2022, the application under section 156(3) of the Code of Criminal Procedure, this was filed by the opposite party number 2.
Opposite party number 2?
Yes.
156(3)?
Yes.
Then
ours is earlier.
Yours is earlier. That is 156(3), that is 7/10/2021.
Yes. And theirs is 7th of April 2022.
156. An application was allowed by the CM Kolkata, registration of the FIR. It is 156(2) by OP number 2.
Yes.
The allegation of forgery digital signature of the opposite party number 2 in the form. That is DIR 12.
Yes, in the Malad, that is what is strange. Malad, in the 156(3) application, he takes up the issue that his signature, digital signature, has been forged in the DIR 12. Now, in the affidavit,
according to that, DIR 12 was filed by the OP number 2 himself.
well, that was a different DIR 12. Now he is claiming that the DIR 12 by which he was made to resign, or his resignation was informed to the ROC, that purportedly contained his fake signature, digital signature. That DIR,
Mr. Ganguly,
Malad, yes.
DIR 12 initially he filed by false personification.
OP number 2,
OP number 2
saying
filed.
petitioner number 1 and 2 has resigned.
Documents were asked for, he couldn't file, so his PR was refused.
His DIR 12 was.
Then you have filed one DIR.
Yes,
DIR
this
12,
is what he challenges here.
that filed by you.
Yes.
Why he signed the DIR?
His signature is not there. Now he thereafter in his affidavit in opposition has changed his stance. I'll take your lordship through the 156(3). Then I'll show to your lordship the stand taken in the affidavit in opposition, where he says, no, that was a mistake in the 156(3). It is really a MGT 7. That is an annual return.
Annual return.
Now the question is whether he can be permitted to change his stance from time to time. That is what we have stated in the 7/4/2022 also. Malad, if your lordship sees, the allegation of forgery of digital signature of the opposite party number 2 in form DIR 12 is unfounded on the face of the record, since the DIR 12 has the digital signature of the petitioner number 1, and even the resolution authorizing such digital signature is dated 29th of May 2021, annexed at page 169 of the form. DIR 12 reflects that resolution. Now then, 8/7/2022, as recently as on 8th of July 2022, CAIS has received a letter from one of its clients, namely Nosi Balasur Infrastructure Company, which is a not-for-profit company and a special purpose vehicle promoted by the North Orissa Chamber of Commerce and Industry, for implementation of various project components at Balasore under Industrial Infrastructure Upgradation Scheme with support of Government of India and Government of Orissa, that the opposite party number 2 has been defrauding them and duping them of their money by misrepresenting to them that he is a director of CAIS and has opened a new bank account to receive money on behalf of CAIS. It is indeed shocking that despite being removed from CAIS in all forms, opposite party number 2 not only continues to misrepresent before various clients of CAIS, but continues to brazenly cheat CAIS by creating new bank accounts in the name of CAIS and siphoning of money from its accounts. So these are the background to the whole case.
You have filed this revision application for quashing the proceedings arose out of a 156(3), that is 7422.
My lord.
Which was allowed actually, which was allowed on 7th April 2022 by the CMM Kolkata.
And it was registered as a FIR on 13/4. Now, if I may take your lordship first to the FIR. Well, it's the certified copy.
Certified copy. Check. In the code of CMM.
Only.
Formal FIR. This is the FIR.
Well, the 156(3) is the certified copy.
150 is an application.
Well, it's the certified copy and it's after page.
I find order of learned CMM.
Yes.
For April.
Well, just after that.
Got it.
Well,
C31 of 2022. C31.
Yes.
Huh?
Yes, my lord.
22.
Now, the three petitioner, the accused persons are before your lordship. Fourth is not.
Huh?
My lord, if your lordship kindly sees, Taposh Kumar Chaudhuri at the top.
Complainant.
The then director of them, since removed. Then Anil Kumar is petitioner number 1. Shalini Mishra is petitioner number 2.
And
Amol Kumar Rai is petitioner number 3.
Amol Kumar Rai is the manager.
Manager.
And Deepak Agarwal, who is he?
Deepak Agarwal was one of the perhaps
directors.
Oh, I gathered the 3 and 4 had gone to. I don't find anything against that. 3 had been accompanied by 4 to the registered office.
Okay. Regarding DIR 12.
My lord, no. Yeah. That they had visited the office of the registered office of CAIS. Okay. Along with that, okay. Let me place the complaint before your lordship. My lord, kindly takes it up from page 2.
Yes.
That your petitioner states that CAIS Engineering Services Private Limited is a company incorporated under the Companies Act 1956. And to that effect, the certificate of incorporation was issued by the this Vide number this, wherein your petitioner was one of the directors of CAIS Engineering Services, having membership number this and having its registered office at this. Then 3 is what they used to do. Then kindly takes it up from 4. That your petitioner further states that till date, where are you going? No, boss, just now. That your petitioner further states that till date, he has been looking after the registered office of the said CAIS Engineering Services Private Limited at this, and recently he visited the office of the Indian Railways for collection of the amount in the name of CAIS Engineering Services Private Limited for such work in the field of railway electrification. The authority concerned of Indian Railways informed your petitioner that he has been removed from his directorship under Section 169 of the Companies Act with effect from 29/5/2021. And as he has been removed from said CAIS Engineering Services Limited, he has no right to work in the field of Indian Railway electrification and to collect money in the name of the company. And the railway authorities has handed over the photocopy of form number DIR 12, wherein your petitioner ascertained that the said accused numbers 1, 2, and 3 had entered into a criminal conspiracy, and in pursuant to the said criminal conspiracy, and by using a declaration with a resolution number this, wherein it was found that your petitioner was authorized by the board of directors of the company to sign that form, including the declaration that all the requirements of the Companies Act 2013 and the rules made thereunder aspect of the subject matter of that form and matters identical thereto have been complied with, and there is declaration that whatever is stated in that form and in the attachment thereto is true, correct, and complete, and no information material to the subject of that form has been suppressed and concealed, and is as per the original records maintained by the companies, showing the signature of the complainant on the said declaration. The photocopy of the form DIR 12 is enclosed herewith for your honor's kind perusal. That the complainant further states that after obtaining the photocopy of form number DIR 12, he found that his signature has been used as forged in the said form number DIR 12 and declaration. That your petitioner further submits that whenever he asked the accused numbers 2 and 3 about the aforesaid commission of offences, both of them became furious and threatened your petitioner with dire consequences that they would teach your petitioner a good lesson later on. And on 7/3/2021, the aforesaid persons had engaged the accused numbers 3 and 4 to fulfill their proposed goal for teaching your petitioner a good lesson. And for that, at the instigation of the accused number 1 and 2, the accused numbers 3 and 4 had been at the registered office of case and assaulted your petitioner by fist and blows on his person. That your petitioner further submits that he was affected by COVID-19 in the month of December 2020, and it was not possible for him to attend the registered office of the company at 5 Fancy Lane. The accused number 1 has stolen the seal of the company and license with a registration number this of his signature and so many valuable documents. And at present, the said accused numbers 2 and 3 in the field of railway electrification in response to the tender of Indian Railways and using the license and seal of the company for that purpose by opening an office in the name of Case Engineering Services Private Limited at 11th floor, unit number this, Kolkata 73. That the said accused number 1 and 2 for their wrongful gain have transferred all the shares of the company Case Engineering Private Limited and by illegally wrongfully has removed your petitioner from the directorship in the aforesaid manner, and by forging the signature of your petitioner in the said form DIR 12 and declaration only to cheat your petitioner, causing wrongful loss to him and causing wrongful gain to them. That the said accused number 1 has removed your petitioner from the directorship of the from the directorship of the company, I think it would be. That your petitioner has reported the matter to the officer in charge, Air Street Police Station, Kolkata, on 7th of March 2022, and has also reported the matter to the Deputy Commissioner of Police, Central Division, Kolkata. The photocopy of the written complaints are enclosed herewith for your honor's kind perusal. That your petitioner prays before your honor to send this petitioner complaint to the officer in charge this. Yep. Yes, sir.
What is the photocopy of DIR 12?
Yes, page 69.
Para 4. Para 4, it is the photocopy of the form DIR 12 is enclosed herewith for your honor's kind perusal.
Well, we have annexed a certified copy of that DIR 12 at page 69.
Page 69.
My lord. Hmm.
Page 69.
This is the first page of the certified copy.
Uh,
Malad kindly sees 70.
Annexure H.
Annexure H. Yes, Malad.
Yes.
Page 70, column 3, CAIS Engineering Services Private Limited.
Uh,
Then kindly sees page 71. Director identification number your lordship has got. Then name Taposh Kumar Choudhury.
Who is he?
He is the opposite party number 2.
Taposh Kumar Choudhury.
Yes. And kindly sees thereafter.
Here, this DIR 12 was filed by Taposh Choudhury.
No,
Previous-
this is the DIR 12 which he says is the subject matter of the forgery.
Okay.
In the 156.3.
That I know. DIR 12.
This DIR 12, if your lordship kindly sees,
Let's file this DIR 12. Either you or
by us.
by you.
He says his digital signature has been misused there.
Where is the digital signature?
It is not there. That is what we are trying to show. Because it's his resignation. Why would it be there?
Only name Taposh Kumar Choudhury.
Yes. Then cessation. Column 8, Millard. Page 71.
Column?
Column 8, Roman 8, at page 71.
1, 8.
Cessation. Then kindly sees 17. Roman 17.
17.
Hereby confirmed that the above mentioned director is not associated with the company with effect from 29/5/2021 due to removal under section 169 of the Companies Act. Now kindly see 73.
Page 73.
My lord. Kindly sees the declaration. I, Anil Kumar.
Where it is?
The declaration portion at the page 73, towards the top, written as declaration.
Declaration, yes.
I, Anil Kumar, then authorized by the board of directors of the company Vide 4 number dated this to sign this form and declare all the requirements of this and this have been complied with. I also declare that all these are true and this to be digitally signed by, kindly sees whose digital signature is there.
Anil Kumar.
Right. Not of Taposh Kumar Choudhury. Then certificate is given by the practicing professional. She is the company secretary, Shruti Rawat.
This is Anil Kumar, digital.
Yes. And then certificate by practicing professional.
Shruti Rawat.
Rawat. Nowhere will your lordship find the name of Taposh Kumar Choudhury. না না ভাই ওইটা ভালো না
Yes.
And the resolution your lordship will find at page 169.
Resolution by the board.
Board. 169. Annexure P.
Yes, got it. Uh,
This is a resolution whereby authority to file form to DIR 12 and other documents in relation to removal of Mr. Taposh Kumar Choudhury from the post of director of the company. And it authorizes Mr. Anil Kumar to file the form DIR 12 and the other documents with the register of companies for removal of Mr. Taposh Kumar Choudhury.
yes.
So far as the DIR 12 is concerned, the allegation in the FIR, your lordship has seen that DIR 12 does not contain his digital signature at all. Now, so far, therefore, the entire allegation with regard to the charge of forgery is per se not there.
Actually, entire allegation of 156(3) is in paragraph 4,
My lord.
whereby he stated that my signature was forged, digital signature. What is the 156(3)?
My lord, these
Yeah. Removed. That is a stolen seal of the company licensed by the registration. His main allegation is in para 4.
My lord.
Form matters identical thereto have been complied with. There is declaration that whatever is stated that in the form is attachment is still correct, suppressed, concealed as per original records maintained by the company. Yes.
Now, this was his initial allegation on the basis whereof the case was started. Now, from that, your lordship will find that his case is not based on proper factual basis at all.
Yes.
Milord, would your lordship permit me to continue on another day?
No, if my learned senior friend has concluded, then my
No,
lord,
it
I
has
can
not
just add in for 5
concluded.
minutes. Thereafter,
Arre,
can my learned senior
I
friend
am
can
not
continue on
feeling-
one more thing.
I'm not
No,
feeling
I think
well.
for-
That's why, if your lordship kindly takes it up on another
Hey.
day, that's all.
কালকে রাতে? ও, কালকে?
আরে ভাই কালকে এরকম করে করছিস কেন? ঠিক আছে কালকেই থাক কালকে কি আছে আমাদের? I can Milord, I can even do it tomorrow since my learned friend is pressing for the same.
Since my learned
I
senior
can-
is not well,
No,
if he
I'm
is not
just-
comfortable tomorrow, any
No,
day
it may be.
subject-
I can do it tomorrow. No problem that way. It's only in the first half I am a bit. Well, I can do it in the second half if it permits.
12th December. Tomorrow I will not be here.
Oh.
I'll have to go to Bhopal.
Oh, very
So I will not be here. 12th December at 2.
কত করে?
At 2.
ও সব ওই ভর্তি
12th December. এই
12
নেই তো আর
ডিসেম্বর
কিছু নেই।
কোথায় গেল? শ্যামল তো দরকারের সময়
বুঝতেও
থাকে না।
তাড়াতাড়ি কিছু নেই। দুটোর সময়। আচ্ছা, কিন্তু সকালে ঠিক আছে at 2.
Well, 12th December at 2 o'clock. Well, it seems even after proper prior
Please,
intimation,
please
the state
inform.
has not appeared. Lordship may kindly put in a direction directing the state to be present with
আরে
the
ও
case.
junior ছিল কিন্তু
Okay.
গোকুলার ছেলেটা ছিল তো, সে আবার কোথায় কেটে বললো?
The state be directed to be present with the case date.
Would the learned advocate, learned counsels appearing on behalf of the parties? Oh, no. Senior counsel on behalf of the petitioner, counsel appearing on behalf of the opposite party. Present and appears on behalf of the state. State is not represented by anybody. Mr. Nandi is not here. Not
No, my lord.
However, release the matter on buried somewhere at 2 p.m. State is directed and advocate because the state is to produce the case type. To produce the case type.
এসে গেছে আমাদের
Huh? CD আছে।
Oh, my lord, there was an interim order till today.
Interim order earlier passed by this court be extended till last week of December. Last week, third week of
Last
First
week
week of
would be
January.
vacation.
first week of January.
Lordship is making the matter part. Lordship can make it part.
এটা
Assigned
assigned
to.
তো। Deep.
Well, 3 to 6 are analogous matter. Your lordship has heard out this matter. The issue involved 3 to 6. Well, the issue involved is proceeding under West Bengal Shops and Establishment Act. Initially, your lordship heard this matter. Your lordship granted the interim order. Thereafter, your lordship has extended this interim order from time to time. Well, I have served upon the state, but today probably they are not appearing. Millet. The only difficulty is this, millet, my interim order is still today. If your lordship kindly sees the last order, your lordship will find that my interim order is still today. So if your lordship kindly extend the interim order and fix a date in the January, millet, I'll do the hearing. We have some.
Who is Mr. Rai?
I mean, only 3 miles.
Ensure attendance of others, your colleague.
Oh, 2 to 4. 2 নয়।
2 to 4 এ আপনি আছেন। Item 3 হচ্ছে 2 to 4, এটাতে আপনি আছেন।
Oh, 2 to 4, হ্যাঁ। So 224.
Well, in one matter, Mr. Sandip Chakraborty is appearing that I can remember.
ও আচ্ছা, কোনটা স্বপন ব্যানার্জি কথা বলতো, তাহলে লিখে রাখি, বলে দেবো। দাঁড়া আমারটা হচ্ছে আচ্ছা, 4 নম্বরে কে আছে? 225 এ স্বপন ব্যানার্জি। আচ্ছা, তারপর সন্দীপ।
Necessary instruction is required on the point of law. What was the point of law?
এটা কপি দাও না।
You need to seek instruction. You need to
last
seek
occasion-
instruction. Yes, it is written in the order.
The instruction that I required, that I wanted at that point of time,
Huh.
that was the issue, millet, my submission was this, millet, a point of law involved in this case is whether on a typographical cyclostyle order sheet the cognizance of the order can be taken. This was the one issue. Second issue was the 202 point. There was no 202. Admittedly, this person is residing outside the jurisdiction of the landed magistrate. Without complying with that, the process has been issued. That was my secondary point. And the third issue is, millet, there are mechanical proceeding of under different penal provisions of the West Bengal Shops and Establishments Act, while there is no violation of the defining sections, millet. That was the three issues I pointed out to your lordships. And if your lordship sees the first order, your lordship will find that after hearing, your lordship was satisfied and your lordship was pleased to pass this order. If your lordship kind enough to take the order dated
এই সন্দীপ, তুমি একটা ম্যাটারে আছো, চারটে ম্যাটার হচ্ছে একসঙ্গে, তুমি 6 নম্বরটা আছো।
first order is on 27th of July 2023 मिले। Thereafter, the matter was taken up on 25th of September.
একটা পিপে কপি দিও, পুরনো ম্যাটার তো তাই।
54-1, 54-2, 54-3.
That is in respect of violation of the rules.
Rules.
I had pointed out to your lordships that the basic allegation against this person is that person did not maintain the register of the requisite registers required under the statute. Now, what
Violation of rules and
violation of
offense under section 21.
Subject to correction, if there is a violation of rule, the proceeding on the offense will be under rule. There cannot be proceeding on the offense under the statute.
Okay.
Because the statute prescribes different provisions for the offense and the proceeding. The rule prescribes different provisions for the offense and the rule. So for the violation of the act, there cannot be proceeding under the rule. For the violation of the rule, there cannot be proceeding under the act. That was my humble submission before your lordship. My primary submission was before your lordship that the order taking cognizance is bad in law because it has been done absolutely in violation of the rule 183 of the criminal rules and orders, and there is no application of judicial mind. If your lordship kindly sees,
Where is that order?
My lord, kindly come.
Order dated first
That's fine, your lordship. Kindly come to page 33.
33.
Page 33, Millet. Order dated 3rd of November 2014.
Received complaint.
My lord, kindly see the manner in which it has been recorded. The sections are putting in the rule 54-1, 54-2, and 54-3 in the handwritten Millet portion. Thereafter, Millet, this is an absolute cyclostyle printed order of taking cognizance, Millet, which, subject to correction by your lordship, Millet, is not in accordance with rule 183, and this mandate has been repeatedly asked by this honorable court. There is a one decision passed by Millet, Justice Amit Talukdar, as his lordship then was. Thereafter, while Millet Justice Bakchi was sitting in the division bench, has passed this mandate, and that has been subsequently followed in a decision passed by my lord Justice Vivek Chaudhary also. So, Millet, at least there are 3 to 4 decisions of this honorable court where this practice has been deprecated, Millet.
Yes. This order you have a say. Cognizance.
Cognizance order, Millet.
Personal affairs of the complaint.
Well,
Hmm.
there are 202 pointer also is there. If your lordship kindly come to the very next page, your lordship will find the petition of complaint. Page 34, Millet. My lord, kindly see the address given over here is a 40/1 Goriahat Road South. There are two persons. One is the Majors Auto Life and
One is
that-
both 40/1.
both 40/1. Now, lordship would kindly come to page 32.
Wait. 34. Address of the petitioners. Two petitioners.
Well, two petitioners. But so far as the there is one petitioner, Millet. Petition number 1. Petition only one. Arun Kumar Singhania is the only petitioner.
One.
He is the permanent resident of Salt Lake. I have annexed the other card, Millet.
What is his name?
Millet, Arun Kumar Singhania.
Or Singhania. Two.
The address is Millet AP 404 Salt Lake Sector 3, Virannagar Municipality.
Singhania. Wrong address. 32. What is in the page 32?
And Millet, the
Sorry.
order taking cognizance which I had pointed out to your lordship
Page
is
30.
also an order issuing summons, Millet.
Solid, page 32. Page. Summons was not, notice was not served.
Millet, there was the 202 inquiry. That was my issue.
202.
My lord. Admittedly, this person is residing outside the territorial limits of the landed magistrate, and having regard to the nature of the proceeding, there has to have an inquiry under the proviso clause of section 202. Well, that was also not done in this case. Well, these are two palpable legal illegality or irregularity involved in this case, which are explicit from the orders itself. And so far as the merits of the case, that no case has been made out, Millet, I'll satisfy your lordship from the complaint on the next day, if your lordship finally permit that, Millet. So if your lordship kindly extend the interim order for a limited period and fix a date in the month of January, Millet.
All are present on behalf of the state?
Yes, only except Sopan Banerjee. Sopan Banerjee is in court, but he is not here.
On fair for accommodation.
I am giving the
a hard learned advocate on behalf of the petition. Advocate learned advocate hearing on the petition. On learned advocates on behalf of the states are present on fair for accommodation. Is the matter on
8th January.
Monthly list, sir? January. Let the matter appear in the monthly list of January.
Monthly list.
Interim order earlier passed by this court be extended till last week of January or until further order, whichever is applicable.
Extremely grateful, Millet. Extremely grateful, Millet. Number 7.
Seven, page 7.
Lord.
Petitioner নেই ফার্স্ট অফ অল রেখে দেবে
এটা নিন
waiting outside why
No, my lord, I was standing in a different court.
you are on behalf of the petition
My lord.
What is the matter? What is the matter?
My lord, it's a 407 application, my lord. 407, my lord. Under CRPC, my lord, for transferring of a case, my lord, pending in the district of, my lord, Kharagpur. Mednipur, my lord. To my Mednipur, my lord, district of Mednipur to Howrah.
District of Mednipur. Kharagpur has not been declared as district.
Yes, my lord. I'm sorry, my lord.
Mednipur, yes.
My lord, may I just bring my page?
Okay, okay. Yes, yes.
My lord would find from the cost title itself, my lord, that it's a application for transferring a special trial case number 79 of 2021, pending, my lord, before learned additional session judge first.
Special trial number arising out of Kharagpur town police station under section. Why special trial?
My lord, it's a case under the Scheduled Caste and Scheduled Tribe Prevention of Atrocities Act.
Special court.
My lord.
Yes.
So, my lord, if your lordship kindly takes up.
Mednipur. First court at Paschim Mednipur.
My lord.
And transferring to the file of learned additions in the first court at Howrah. Why?
My lord, may kindly take up the grounds once.
What are the grounds?
My lord, would find that at page 11, my lord, the grounds.
Who has filed this application?
This has been filed on behalf of the de facto complainant, my lord.
De facto?
My lord.
Yes.
My lord, may seize, my lord. Ground.
The de facto complainant? What
my
is
lord,
his name?
she's a homemaker, my lord.
Suparna De.
Suparna De, my lord.
Wife of Prosenjit De, residence of village. What are the grounds?
At the outset, I may tell your lordship, my lord, that she is a housewife having 2 children, my lord. And she resides at Howrah, my lord. So, my lord, the case, your lordship will find it from the synopsis itself, my lord. That she
Only
was
her residence is where he lost complaint. Where she lost.
She lost actually the incident happened there in Kharagpur, my lord.
Where she lost complaint.
Since the incident happened in Kharagpur, she lost the complaint with, my lord, Kharagpur town police station, my lord. Now, my lord, she is praying to get the case transferred, my lord, from Kharagpur to Howrah on the grounds which has been stated, my lord, at page 11, my lord. So, lord, she kindly takes up page 11. My lord, if I read out the first clause, my lord, and then I shall explain before your lordship, my lord. For that, the non-cooperation from the end of the police authorities from the very inception of the instant case with not incorporating the relevant sections of the Prevention of Atrocities Act has caused prejudice to the petitioner. My lord knows, my lord, that the bedrock of an investigation starts with recording of the complaint, my lord.
Investigation completed? No.
Completed, my lord. I filed a 173(8). For last 1 year, my lord, it was pending. It was not taken up. If your lordship sees the fate of the trial, lordship will realize, my lord, and lordship conscience will be struck, my lord, and lordship will be most humbly, my lord, will concede to my prayers, my lord.
173(8), one application has been filed.
My lord. Filed.
For further investigation.
For further
has not been investigated.
For further investigation.
Allegation of fraud. What about that application? Why?
It is for the last one. It has never been heard, my lord. Several times it was fixed for hearing. It was never taken up, my lord. If your lordship sees the orders that have been passed in this particular case, my lord, lordship will be away stuck, my lord.
Intentionally stressed upon the section so and so. FIR copy of the registering same despite mandate of the law being otherwise. HR did not provide the copy of it. For that investigation has only been table work. No effective investigation has been carried out. All are 173(8). It is pending before the court.
Yes, my lord. For
so
last
I can pass an order directing me
that,
to hear the application.
That is one aspect of the matter.
Transfer.
That is one aspect of the matter, my lord. Kindly sees the other aspect. They are enumerated in the ground.
Certain time frame, my lord, let that application be heard out by the land trial.
That is, my lord, just one of the many grounds.
No,
this cannot be the ground of transfer.
My lord, there are 18 grounds that I have enumerated. Not only one.
You are running after POA. All the provisions. Prosecutor states not to be one of the. You are saying allegations, sir. POA. Everything.
My lord,
All the points
No.
relates to
yes, my lord.
POA.
Yes, my lord.
So 173 is pending. Why?
My lord, that is if conducting with respect to investigation. With respect to trial, kindly sees, my lord, how the trial has progressed.
The investigation has not trial.
I mean, the day-to-day, my
You
lord.
have filed 173.
My lord, I stand correct, my lord.
This is not the stage of trial.
It is not, my lord. I stand correct, my lord. I'm sorry, my lord. The proceedings, kindly see the proceedings, how it have proceeded day to day, my lord. Lordship,
Proceeding means
my lord, the day-to-day proceeding, bail application, how they have,
filed 173A.
my lord.
You have taken all the allegation against the court concerned.
My lord, there are, with deepest of respect, my lord, there are. If I cannot satisfy your lordship, lordship may dismiss it, my lord. If I cannot satisfy your lordship, my lord, it is always open to your lordship, my lord.
Where it is?
My lord, kindly takes up, my lord, page 83 once, my lord. My lord, 83 is a culmination, my lord. If your lordship takes the certified copy of the order sheet, my lord, that is not paginated, my lord. That will be at the my lord end of the lordship's brief, my lord.
Order dated.
My lord, kindly takes up order dated 24/11/2021, my lord. My lord may see, my lord, the respondents page, my lord. It is, my lord, the certified copy, order dated order copy, my lord. I have attached at the end of your lordship's brief, my lord. Order number 5 dated 24th November 2021, my lord.
Order dated?
Order number 5, my lord, dated 24th of November 2021.
5.
Yes, ma'am.
Order number 18.
Order number 5, my lord. My lord, may I assist your lordship, my lord?
You have marked page.
No,
What is the
if
page?
it's the certified copy, I could not mark page, my lord. May I assist your lordship? If your lordship kindly hands over the brief to me, my lord.
Order number?
Order number 5, my lord, 24/11/2021.
Certified copy. 5, huh? Yes.
My lord, may see, my lord, the opposite parties herein, my lord, were granted bail, my lord, without any notice to me, my lord. Now, my lord, when I bought this,
There is
in
remedy,
the-
sir.
no.
You can file a cancellation of bail.
my lord, kindly see, when I bought this to the notice of the learned trial judge, my lord, order number 10 dated 25/8/2022.
Order number?
Order number 10, my lord.
These are all not ground for transfer, sir. Order number 10, yes.
My lord, sees, my lord.
CBR document without taking any steps are absent. File today's fixed for so and so. Learned Naik is present. Prosecution. Accused person failed to take steps. It is now warrant was issued.
Warrant was issued, my lord. But this warrant prejudices me from this perspective, my lord. Kindly appreciate, my lord. Why this warrant was issued? Because they could not take step. But what was my allegation, my lord? The allegation was the procedure. These are two different perspectives from which we are seeing the cancellation. This order will
Sir, did you
suggest.
file any application for cancellation of bail?
We filed, my lord. That was
Where is that application?
that got infructuous, my lord.
No, that
on
Where is that application? Did you annex this application?
My lord, annex.
Where it is? Cancellation of bail.
Yes, my lord.
Where?
They have tried twice.
My lord would find that
Page
at page 87, my lord.
80,
87, my lord.
87.
My lord.
Bail has already been cancelled.
Yeah, no, my lord.
See page 89.
89 is in view of the.
Bail has already been cancelled by additional district judge 1.
Yes, my lord. On what ground? They failed to take step, not because the learned judge failed to give notice, my lord.
Okay. When you have filed, where is your application? Where is your application for cancellation of bail before the learned judge?
We brought it before the notice of the learned judge, verbally, my lord.
Verbally?
My lord. On that way, why else?
Can it be possible to cancel the bail on verbal submission, sir? Did you ever hear?
No, my lord. But my lord, what we are trying to canvass before your lordship is that the ground on which the bail was cancelled was not at all a relevant ground, my lord. The parties failed to take.
Was issued.
My lord.
Bail bond cancelled automatically.
My lord.
Even if there is no order of cancellation of bond,
my lord,
bail bond shall stand cancelled as and when warrant is issued.
My lord, that is one aspect of the matter, my lord. Now your lordship sees order number 11. The
You
order
have
immediate
said that you have prayed for cancellation of bail. Where is that application?
before the court below, my lord.
Where is that application?
No, I have not, my lord. If I have said that, my lord, it's because I could not articulate myself properly.
Sir, you have filed one cancellation of bail before petition for cancellation of bail before the learned trial court. Where is that application?
I did not, my lord. I'm sorry.
Did not file?
No, not file.
Why are you misleading this court?
No, I'm saying, my lord, that I brought to the notice of the learned trial.
Why you are misleading this court?
I'm not, my lord. With deepest of humility, my lord, I render my unconditional apology, my lord. If I have been understood that way, my lord, I never intend to say that, my lord.
Non-appearance of the accused led the learned judge
My
to
lord.
issue warrant. What wrong he has done? What wrong he has done? Cancellation of bail?
My lord, that is one aspect of the matter. May I be permitted to place an
Get yourself prepared first, then come for hearing.
my lord. As your lordship please.
Otherwise, I'll have to impose huge amount of fine.
My lord, I shall come prepared.
Please get yourself prepared. All your grounds are regarding PUA. That is 173. You can file and you can submit that necessary direction be given to the learned judge for early disposal of 173. All the grounds relates to PUA. PUA has not been investigated.
My lord, I don't know, my lord. My limited experience on this side of the my lord, bar, my lord, is this, my lord, that
Sir,
there
you are
is
moving before a bench, the Honorable High Court.
my lord,
You should get yourself prepared first.
my lord,
You must know your case.
my lord,
Your case is police didn't investigate the case properly. Entire case.
my lord.
Entire case, police didn't investigate the properly. You can submit that necessary direction be given to the learned judge to dispose of the application within 15 days, within 1 month,
My
within 10 days.
Well.
173(8).
my lord.
You are
Yes.
saying that you have filed bail application, cancellation of bail, nothing was done, this was not done, this was not done. How the proceeding will be continued if your application is pending before the learned trial judge, 173(8)? How?
That's true, my lord. They cannot.
Can it be proceeded with?
Cannot be. My
So you are standing in the way of proceeding of the case. You yourself.
lord. My lord.
Simple, come before this
Right.
court simply with a prayer for early disposal of 173(8).
My lord.
Yes, matter is pending, there is a stay, my lord.
How can it be proceeded with? You
Absolutely,
are standing in the way himself
absolute.
and you are showing the
Contrary stand has
My
been
lord,
taken by.
lordship.
provision.
My lord, may I just bring one thing to your lordship's notice, my lord?
Sir, get yourself prepared. All the grounds mentioned in your application is nothing but inaction of the police
My lord.
investigation. That's why you have filed, rightly we have filed one application under section 178 of the
Dispose of
CRPC.
Korea now.
My lord.
That should be heard.
Dispose of Korea now.
Then if you are aggrieved, then you come to Honorable Court.
My lord.
Why are you wasting the time of the Honorable Court
My lord.
without preparing yourself? Go through your grounds.
My lord.
ওইটাকে dispose of করিয়ে নাও তাহলে তো মামলাটা শেষ হবে।
My lord, there is an interim order which is subsisting till today, my lord. If your lordships kindly extend that interim order.
Then again you are standing
Again.
in the way. Again you are standing in the way. One side, one hand you are saying that matter is not proceeding. And other way, you are submitting that matter may be stopped. Trial should be
Just
stopped.
contrary
What
stand,
you
my
are
lord.
saying?
No, my lord. I'm never saying that the proceeding has
Proceeding
not.
is being stopped by you by filing
I-
this application instead of filing simple application for early hearing of 173(8) of the CRPC.
My lord, a warrant has been issued. There is an order which says that if there is an intent to surrender, so you need not to be taken into custody. A date is fixed for hearing. My lord, in criminal jurisprudence, with greatest of respect, my lord, this is unheard of.
You are making allegation against the judge.
Against the order, my lord.
Where is the allegation? They surrendered instead of taking their surrender. Where is that order?
Well, kindly take some order 11, your lordship.
Take it.
Whatever order he is referring, he has challenged and he had come up before your lordship and your lordship had disposed of the cancellation application before serve it. On
Kindly see, my lord, order number 11, how the trial has proceeded.
Where is?
My lord, that is, my lord, 83. If your lordship takes up the paginated page, my lord, order 11, lordship will find at page 83 of your lordship's brief, my lord.
Don't try to mislead this court, sir.
Never, my lord.
Otherwise, you have to face the music.
My lord.
Hard considered, prayer is allowed. The accused of strength of put up petition, learned advocate of the file a petition praying for intent to surrender and recall W. Hard considered, prayer is allowed. 15A, issue notice upon the defective complainant. Rightly, Srimati Suparna Des and so for producing the defective complaint on it for hearing. IO. Rightly done.
My lord,
What wrong he has done?
a warrant was pending execution against the opposite parties, my lord. They come for surrender. They were not taken into custody. A date was fixed, my lord.
Huh.
So, my lord, my lord, our law permits this to, my lord.
No proceeding shall be taken up.
My lord.
Section 15 of the SC Act
My lord.
clearly spells out that
My lord.
no proceeding shall be drawn up.
My lord.
No proceeding shall be
My lord.
taken up
My lord.
without presence of defective
Absolutely, my lord. Then when they surrendered, they should have been taken into custody.
That is why he was asked to serve notice upon the defective
But
complaint.
then, my lord, with deepest of humility at my command, my lord, whether this will not be a proceeding in itself, my lord.
This court for hearing of the bail for modification of the bail order of the accused. It was prayer for recall.
Yes, recall was never allowed. Recall was never allowed, my lord. Recall was never allowed. There was an execution pending against them, my lord. They appeared before the learned court below. They intend to surrender, my lord. They were not taken into surrender and a date was fixed.
Whether they were present in the court or not. Recall and intent to surrender, what does it mean?
Can they, my lord, do it without surrendering? Can they make an application?
That is another question. That petition was not taken up without presence of defective complainant. Rightly under section 15.
My lord, but this is a proceeding.
Where is the order that accused are present?
My lord, lordship had dismissed on application for cancellation of bail in which your lordship has found, my lord, that they were present in the court below, my lord.
Where?
In the order, because your lordship said this is not an anticipatory bail, it is a regular bail application.
Sir, they intend to, the learned advocate files an application that accused are intend to surrender before the court, recall the order,
my lord,
and recall WA,
my lord,
surrender.
My lord.
Where is the order that accused are present and is taken into custody? Question of taken into custody cannot be. Only petition has been filed, put up petition. And court asks them to ask him to serve notice under section 15(1).
Yes, my lord. So, my lord, whether this is a proceeding, the question of law that would fall for your lordship's consideration.
At the time, initial time when you have started started your
arguments, my lord. Yes,
that she is residing at Howrah, so case may be transferred.
That was my.
All our allegations are poor, police inaction, police didn't investigate this case properly. So you have filed once.
And the proceedings also, my lord.
How the proceeding will start if that application is not?
I am on the nature of the proceeding, my lord. The way the proceedings has been conducted, my lord. Not on the flow or the space of this proceeding, my lord. Proceeding has gone on in its usual space, my lord. But the way the proceeding has been conducted.
Did you go through the grounds mentioned here?
My lord, there are 18 grounds, my lord. So lordship kindly sees, my lord.
Application,
my lord.
Did you go through?
My lord.
What are the grounds? What are the grounds?
My lord, if you see page number 12 onwards, my lord.
I am showing what you have stated.
If it's your lordship's pleasure, my lord, to come to ground number 13 of your lordship's brief, my lord, at page 12. Lordships may also consider ground 15, my lord.
Ground number 16. What is written in ground number 16, internal page 11?
Yes,
what is written?
Yes, internal page 30.
What is written?
My lord, the learned trial code had failed to capture the essence of time-bound trial under the POA Act, my lord.
How could it be?
My lord, it was still I filed this application before.
How could it be? You are standing in the way.
But lord, my lord, if my applications are hard out on time, I will not stand, but they are not.
Why didn't you come before this court for early disposal of this application on this ground? Why?
My lord,
why didn't come?
My lord, I am exploring an alternative remedy, my lord.
Exploring. You are exploring how to stall the trial.
No, my lord, I am the de
Then-
facto complainant. What will I gain from stalling the trial, my
That
lord?
is the problem. You are the de facto complainant. You are saying that the learned trial court has failed to capture the essence of time-bound trial.
Yes, my lord.
Everything is there,
My
but you are standing in the way. You are praying for stay of the extension of interim order extension. What is this?
My lord, if the trial goes on in this fashion, my lord, what will I expect from the outcome of this trial, my lord? Will
Outcome?
justice? I had an, my lord, at the inception, may I say this?
What is the trial? What wrong he has done?
My lord, I had an injunction order in my favor, my lord. From my own house, I have been thrown out.
It may be that is civil matter. I'm not on that. What wrong he has done, court?
My lord, kindly seize
Which
ground
order?
13,
Which order he has done?
13, my
Which order he
lord.
has done?
Kindly
First
seize,
wrong
my lord.
against you.
My lord, date were fixed for the hearing of my petition. None were heard. 5 petitions are pending, my lord, before the learned
What
court.
petitions?
My lord, kindly seize the petition.
So I'm passing order. All the pending applications you have filed be disposed of within 1 month. Is it okay?
My lord, may I take instructions, my lord?
Come tomorrow.
Lord.
Hey, Monday, Tuesday. Really.
My lord, we extend the interview.
Instruction from defective complainant.
Yes, my lord, my client.
You have been appointed as.
My lord, I have not been appointed to, my lord, to take that order from your lordship, my lord.
Sir, your main application is proceeding. So far, I find the grounds. Proceeding is not is not going on.
My lord,
Your so many applications are pending.
my lord.
Make a prayer that all the applications, pending applications, be disposed of within short time.
My lord,
Matter ends.
my lord. My lord, I shall convey your lordship's view to my client, my lord, and take instruction
When
accordingly.
will come? Tuesday.
Any day your lordship fixes.
Tuesday. চলুন অর্ডার দিতে তো মঙ্গলবার দিন না
My lord, kindly
Tuesday in the morning.
My lord, kindly extend the interim period till Tuesday, my lord.
Interim order earlier extended. Hard learned advocate appearing on behalf of the petitioner. What is the number? Item number?
My lord, item number 7, my lord.
7.
7, my lord.
The assigned matter come on that day.
Hard learned.
On fair for accommodation. Matter be listed on মঙ্গলবার কি আছে কত 30
And Lord,
38
state and de facto complaint lawyer is also represented, my lord.
state learned advocate on behalf of the de facto complaint.
My lord, the opposite party. Sorry, opposite.
party. Opposite
Accused
party as
person.
well as state are present. Represented for state as well as opposite parties are being represented by their respective learned advocates. আচ্ছা এটা কবে হচ্ছে 4 5 5th
My lord,
Fifth.
any day other than 5th, my lord. I have a matter on 5th, my lord.
6th 6th is interim order be extended till second week of December. Second week of
901.
second week of December. Done this way. Please come on that day. I will pass order directing all the pending applications
To be heard within
court
certain time.
be heard and disposed of within 1 month.
I'm grateful, my lord.
Next, portable.
Obliged.
But I am appealing for the petitioner, my lord.
I am for the
Your lordship heard this matter earlier, my lord. On the earlier occasion.
I am for the opposite party.
What is the matter?
No, this is the petition before your lordship is the wife. There was an order by this honorable court, interim order, on 17th of April 2015. On the last occasion, even on the several last occasion, your lordship directed the opposite party, the husband,
You are
to
on.
comply
for
with
the
the
husband,
to
madam.
comply
Yes.
with the order of this honorable court to pay the interim maintenance for 6 months that they have not done till 2015.
Lordship, yesterday I have informed my client that my lord, the petitioner my lord already remarried my lord to
Did you
another
file
person.
any execution before the trial court?
Yes, I have filed an execution case before the trial. Lord, I have already pointed out to your lordship that the petitioner had remarried.
Huh?
But the petitioner, the wife, had remarried. Their divorce, there was a divorce, but
After
this
getting a
this
decree of
did not apply to maintenance before remarriage and during the interim period. The interim maintenance is pending. That has to be paid.
When will pay?
Yesterday I have informed only my lord that he informed me that she remarried my lord, and lordship, that's why lordship she could not.
She remarried. That is prior payment.
That I have to take instruction my lord during which period my lord I have to pay my lord.
File
But,
contempt application. File contempt application. Then I will see whether you will be able to make payment or not.
Lordship.
Please ask your client. Contempt rule will be issued for non-compliance of order of this court.
I will file my along with the
This is
executive
the matter at both sides.
execution case.
Are learned advocates appearing on behalf of the parties to this revision application? List the matter on. This is the matter on when I will fix. 19th. Yeah, 19th. Huh? Yeah.
Miller, from 19 Miller, I have some personal difficulties.
January monthly list.
January.
Monthly
January.
list January.
Great.
Please try to
Lordship.
comply.
Lordship.
Please try to comply. Otherwise, you have to face the.
Lordship.
Great.
বলা ছিল হ্যাঁ এখানে নেই নেক্সট
Item number 12.
ওই তো টপিক হ্যাঁ
363 and 365.
12
Thereafter, matter was, but thereafter marriage was held by. That has been tagged to as an annexure, but there is no.
petitioner is not appearing. It's responsible for.
They come for worship that we have already married each other.
Right. From the record, it appears. Principal amount is 90,000.
90,000.
Then, yes, completed. Next.
Insurance in the 313 also. The 313, the accused admitted that he took loan from the company, but he denied the amount 90,000. He specifically stated the amount is 20,000 and he gave a check, blank check for security purpose to the complainant, and it was filled up by company. He never dispute his signature also because he admitted his loan, but the amount is 20,000 instead of 90,000. Now, Lordship, in this case, two money receipts were exhibited in respect of two different agreements, that is of March 2016 and October 2017. Now, in all the money receipts, admittedly, Lordship, the signature of the accused person is there. And there is no denial on the signature because he admits that there was a loan. But if your Lordship see the first exhibit, which was executed on March 2016, that contains a non-judicial stamping. But the later on, the October 17, only money receipt, no non-judicial stamping. Now, the complainant is a professional money lender. Now, from a professional money lender, this kind of faulty preparation of document, when he executed one document with non-judicial stamp paper, another agreement, no non-judicial, only signature and on document. Now, another thing is this, Lordship. If your Lordship sees the exhibit 5, then there is a mentioning of paying of interest. But in exhibit 5/1, there is no mentioning about paying of interest.
5/1.
5/1. There is no
as there was no, license was not extended.
license was not extended.
So he's not entitled to interest.
Get the interest.
That's why he didn't mention the interest.
Now, in exhibit 5/1, he amalgamate the earlier 60,000 and 30,000 and prepared a total 90,000 money receipt. Now, in 5, which was prepared in March 2016, it is stated that there will be an interest. But nowhere from the starting from complaint to evidence, the complainant stated that he received the interest. Now, being a money lender for 16 to 18, without taking any interest, he only, as per prosecution, I given check of 90,000. So, without any interest, he only accepted the principal amount check. Without any interest, whereas his agreement specifically speaks about interest. So, if I believe the prosecution means the complaint is true, then Lordship, the principal amount is 90,000 as per complainant's claim. I gave the check as per complainant's claim of 90,000. Without any interest, he accepted, being a professional money lender. This creates a doubt about, in my mind, subject to correction by your Lordship. Now, another thing is this, Lordship. So far as this March 2016 agreement is concerned, it speaks about interest. Now, in October 2017, another agreement was executed. But nowhere it is mentioned that since March 2016 to September 2017, I paid the interest of the first loan amount or not. Because if I'd never paid, then I'm a defaulter. Now, complainant being a professional money lender, giving monetary assistance to a defaulter with only 90,000 security. So, subject to correction, Lordship, the defense never denied that no loan was executed. Defense accepted that I took monetary
assistance of 20,000. Defense accepted the check was given as security purpose. There is no denial that that is not my signature also.
But you didn't disclose the date of taking loan, whether you have paid interest, nothing. You also didn't produce any evidence.
Didn't adduce any evidence, only the question which was put and in answer in 330. There is a fault on part of the accused. I am admitting, because I can develop at this stage.
After examining under section 313, you had enough opportunity to produce evidence. That I took loan 20,000 on so and so date, and and this is the receipt. You could show any receipt in support of
Nothing has been done on the
20,000,
part of the accused.
or I paid interest. You also didn't
Nothing.
disclose.
Admittedly, there is nothing.
Now, it is a proceeding under section 138. We are only concerned with the check amount. Check you have issued, your signature is there. According to you, your case is that you should blank check. This is only free, and you have taken only 20,000. This only free.
That is only my defense observation. And that is why he is agreeable to pay 50,000. That is why the accused now agreeable to pay 50,000. 50,000.
Why 50? You have taken loan only
20,000.
20,000.
20,000.
Why 50?
I asked him to pay 90,000. That is why he said I can pay up to 50,000.
Okay, complete. Hey, wait, here we go.
Great.
এগুলো আলাদা রাখুন, এইটা তিনটেই তো লাগবে, বেঁধে রাখুন। Yes. কোনটা? হ্যাঁ?
Just like that. No, short possible.
Extension হচ্ছে না, extension করা হচ্ছে। It's a matter of some letters. Time to time they have prayed. The grant application is there. They have extended the stay order. But what I'm on is it's a matter of 2011. So may extend it for a limited period and may fix up a
revision application.
Well, it's a revisional application. They have come up for washing, I guess.
Washing.
Well, I'll just check the petition first.
Washing.
And under section, FIR was lodged under section 341, 506, 427, 354, and 34. So since Malad is a very old matter, Malad may extend today, but Malad may extend it for a limited period so that Malad, once after vacation or any time, Malad, we can, Malad, I may produce the case diary and Malad may dispose of this matter because
you are on behalf of the state.
I'm on behalf of the state. Malad, they have filed a CRAN application 2023, Malad, for extension of the earlier stay order that has been granted. In the meantime, Malad, I'll get this. Anyway, it was staged, so status mark won't have improved much. But at what stage the matter was stayed, Malad, I'll get that information also, and Malad, I'll get the necessary documents, the case diary and everything. ঠিক আছে।
Advocate appearing on, I'm passing this order.
Well,
Advocate appearing on your state has submitted that
Well, I'm opposing their extension formally.
opposes the prayer for extension formally. The extension of interim opposes the prayer for extension of interim order. Formally. From the record, it appears that the 13th the order of stay was granted by the order dated 17/4/2017 and it was extended time to time. Lastly on 1/11/2019 for a period of 4 weeks.
All confirmed.
However, the Grand Chief, however, considering all facts and circumstances of this case, though the plan application was filed after expiry of the period of extension by the order dated 11/11/2019, there shall be stay of further proceeding in GR case number 4447. There shall be stay of further proceeding in GR case number 4447 of 2011 pending before the Judicial Magistrate Third Court, Behrampur, Murshidabad, Third Court, for a period of 8 weeks.
And after the winter vacation.
For a period of 8 weeks. 8 weeks is the matter. Let the matter appear in the monthly list of January.
Fine.
Okay. And 3 stanzas for that.
Great.
I'm so sorry, my lord, my apology.
Extended, not extended. Not extended. I mean, considering all facts and circumstances, there shall be a stay order for 8 weeks. For 8 weeks, and matter will be come up in the January monthly list.
Deeply.
Extension prior to expiry of the
Right, your lordship is right.
4 week.
I'm grateful for the generosity, my
Much
lord.
later than
Right, your lordship is absolutely
Better.
much.
they are filed in the year 2023.
19.
So your lordship has in fact reimposed the interim order. Well, I'm deeply obliged for the generosity, my lord. Deeply.
Sure. Yes.
This matter, number 10.
Yes.
Mr. Shekhar Kumar Basu is appearing. That CBI matter regarding the jurisdiction.
It was initiated where?
Well, it was initiated in Kolkata.
Not,
CBI, your lordship recollects after exchanging of affidavits between the parties. My lord, I have argued, and my lord, today the date is fixed for
reply, Millet.
reply.
But
The point your lordship remembers that the matter is pending before the Ahmedabad court, and whether
it was initiated at Ahmedabad.
yes,
Ahmedabad had
Millet, the
yes.
FIR has been registered at, I'm not.
Why
going to
the
enter into
matter has come here for inquiry?
for quashing before your lordship.
No, not quashing. Why the
My
Millet,
lord,
the case has
because
been
of-
registered
just
at
a
the
minute,
police
sir.
station, which is within the jurisdiction of the Kolkata Millet. They have, their claim is that although they have registered the FIR at Kolkata, they did not place it before the jurisdictional court of Kolkata. Instead of that, they have placed it for the first time before the Ahmedabad court.
Probably, possibly, if I have not, so far I recollect that he showed one notification.
Millet, that
Yes.
notification,
Central government
Annex.
notification.
Millet, that
CBI
notification
yes,
regarding
Shown.
all throughout
Noti-
India.
Millet, the
I have
noti-
annexed that.
notification
I have
regarding
annexed that.
the jurisdiction of the investigating agency to investigate the offense.
Yes.
There is nothing more than. I don't want to enter into the merits of the case because Mr. Shekhar Kumar Basu is addressing in your lordship. Millet. Today, I will give some reply in piecemeal and he will that. I do not kindly pardon me, Millet. He requested if your lordship be kind enough to take up this matter on 14th, Millet.
14, I have difficulty, then kindly takes on 15th according to convenience of your lordship.
15 December.
Yes.
15 December. 15 December in the second half, Millet, if your lordship be kind enough.
At 2 p.m. 15 December.
15th.
Equal to close it. Close it. Close it. 15 December. Close it.
At 2:30 Millet.
Close. Yes.
2.
2 at 2.
Extremely grateful, Millet. Extremely.
Equal to. Next. Go ahead.